And if you're just joining us, please do type into the chat your city and your county that you are commissioned in. And let me just put this out there for those of you that are on virtual. Hopefully, who knows how often you're able to do meetings or need to do meetings, but if you have a headshot of yourself, you can actually upload that to your profile, and that way, when you're not visible as far as on camera, at least I still have an image that I can refer to, so I can kind of get an idea of who you are with your face, with your name. That helps me over time really remember notaries or anyone in that matter. Since again, if you are not comfortable with being on camera, that would be the next second thing I ask, is that you are able to upload a photo again of yourself, so I can actually know who I'm speaking with, especially if you have a question or make want to make a comment. I will have someone to actually recognize when that time comes. I hope everyone has had a pleasant day so far. All right, we're going to go ahead and get started on tonight's topic. Let me go ahead and get my screen together for you. All right, so we're going to go over the public in Notary Public, how to stay impartial and avoid notary fraud. Unfortunately, that is a situation and issue that's happening not just in North Carolina, but around the globe. So hopefully this can be very helpful for all of you that are tuning in. So when it comes to, again, the public and notary public, understanding your role as an impartial officer of the state, what does public actually mean? The definition is notaries are appointed to serve the public, not just the individual signer. Impartiality, you are a neutral third party witness, not an advocate for the signer or the business. And then to keep it non discrimination, you cannot refuse service based on race, religion, national origin, age, or disability. And the guardrail is your commission is a state appointment to protect the public from fraud, not to facilitate personal or business agendas. So that's really important to understand. Again, what impartiality is when we're dealing with our ministerial duties, because some individuals may actually get it confused. And when we work in this capacity, we should be unbiased when it comes to how we go about notarizing, and it should be treating everyone equal. Okay. Now, of course, there's provisions that we will cover as far as why we can't move forward or shouldn't move forward with notarizations, depending on certain situations. So the guardian against fraud prevention, our prevention role is to fraud prevention is your primary responsibility as an officer of the state. When you see red flags like there's an urgency, there's confusion, or strong displays of emotion from a client, that can be indicators of coercion or fraud. So that is something, again, when you are learning how to read body language, this is really important. Why we need to actually pay attention to the individual, not just the idea itself that they're presenting to us when we are actually working in this capacity. So again, red flags are there. We just want to make sure that we're doing our due diligence to ask certain questions to ensure that we, beyond a shadow of a doubt, can feel confident that this person is willingly actually signing this document, understand what they're signing before we notarize it. There are no exceptions. You do not have the discretion to waive laws based on a sad story or urgent circumstances. And then there's consequences that we must face if we actually, again, do not follow the law. Failing to uphold these standards can lead to revoked commissions and potential criminal charges. So, again, the goal is to keep you out of the situation of violating the law, where you are going to deal with consequences when you're caught. So, there's case studies. The first one is the importance of personal appearance. The scenario is a family presents a DMV title for a vehicle belonging to a deceased relative. They have the death certificate and feel that since they have proof of death, they can sign the deceased name. What the notary mistake was, they allowed the family to sign on behalf of the deceased. And then when it comes to the reality legally, there was no personal appearance by the principal, okay, because they were deceased. Notarizing a signature when the signer is deceased and absent is illegal. All right. The outcome, the notary was charged with a crime for performing an unlawful notarial act. And again, when you think about exactly what we have the ability to do, there are certain things that we have to understand how to handle. And personal appearance is always going to be, the person has to be in front of you that you are notarizing the name of, unless you're dealing with a power of attorney situation. And unless that document or that person says they're the power of attorney, you would know that that person is not them based on the identification presented before you, with the name not matching with what's on the document. So when they sign their name, they have to say their signature as far as who they are, as well as for the principal signer, okay, when it comes to who they were given the power to sign for. So those things, again, are very clear when someone is working in that capacity or signing on the capacity of another. So that is something that you always want to make sure you understand when the actual principal is not before you. That's the exception, is when they do have an attorney in fact or a power of attorney on their behalf signing for them. And that can only be done if the person is living. All right. When a person is deceased, it's a whole different situation, and you're dealing with an executor or a beneficiary when it comes to how those documents are actually presented. So, again, the more you study to actually understand different positions that a person may hold for another, is going to be very important for you to understand and make sure you're doing the right thing when notarizing or declining a notary for a customer. So, case study number two, when helping becomes illegal. So, if a notary knowingly seals an owner exemption affidavit that is unsigned, the notary's unlicensed son uses this document to get a homeowner to sign later, authorizing the son to perform construction work. The mistake the notary makes is affixing a signature and seal to an incomplete document without verifying identity or witnessing the signature. The reality of this legally is the homeowner never appeared before the notary. This act facilitated unlicensed construction and fraud. The outcome, both the notary and the son were convicted of crimes because, again, it was not done by the actual signer giving authorization on this document. So, again, hopefully you guys would never deal with a situation like this, not knowing how to, again, decline, let them know that you have to have the signer before you to either witness their signature or have them acknowledge the signature of theirs on the document, willingly actually signing it ahead of time. So, again, those things are something that you want to make sure you're taking the time to pay attention to if this is brought before you. And then case study, excuse me, number three, the hospital bed trap. So a notary goes to a home or hospital where they are told the principal is too ill to come to the door and has already signed the document. The notary is pressured with a heart-wrenching story, and that often comes with a story. And the notary's mistake in this case is the notary proceeded to notarize despite the principal being absent and unable to confirm identity or intent. The reality legally is personal appearance is non-negotiable. Without it, you cannot notarize the document. And again, unless it's a subscribing witness situation, once again, you have to understand what is really happening, what's taking place, so you know exactly how to handle the outcome. In this situation, the outcome, the property was lost by the rightful owner. The notary lost their commission, and the notary was criminally charged as well. Your authority versus the attorney's authority. So the unauthorized practice of law boundary, avoiding the unauthorized practice of law, the scope for notaries. You want to verify identity, witness signatures, and administer oaths, especially when there is a direct for an oath on information. You should never miss that step. For an attorney scope, they explain the document's purpose, provide legal advice, or choose the type of certificate, whether it's a direct versus an acknowledgement for the client. So when it comes to the Notario trap, meaning this is notary in Spanish, unlike some other countries, a United States Notary Public does not have high-level legal powers. So when it comes to what that word really means for other countries, those individuals are notaries that have the same powers as an attorney, but that is not how that is here for us in North Carolina or in the US. So it's very important to know again, if you see someone who actually displays that on their social media, at their place of business, ask them, are they an attorney? And hopefully you can educate them on why they don't need to use that language without actually making it very clear to give a disclaimer that they're not an attorney to offer legal advice. So again, if you're looking out for your fellow notaries, this is how we can do that by letting them know how to correct certain things that can become a problem if they don't. And if the right or if someone else happens to see it, it could cause them problems if they decide to report them with the assumption that they're actually doing things that's beyond notary. So again, it's very important that we look out for each other the best way possible by just giving each other a helping hand with information if the other person is willing to receive it. When it comes to practical application and when to say no. So when to refuse. If the signer cannot physically or virtually appear, and again, virtually, there's no virtual as of right now, but in the future, of course, when we're able to do remote notarizations online, that will apply for that scenario. Signer is confused, sedated, or lacks mental competence. Okay. These are reasons why you should not move forward because, again, if you can actually identify the person having difficulty, then again, we have the authority to say no. We are not um, we are not bound to actually notarize for anyone just because we're a notary. So we can say no. That is safer than to be sorry later for moving forward with something that is not correct. Okay, that can cause a lot of problems for you and the signers. Document is missing pages or contains blanks when not permitted. When we are wanting to notarize or someone wants to have a document notarized, there has been cases I've heard where the signer will just bring the document where notary will actually notarize the document without the preceding pages. Well, if this happens to you, decline to move forward because we supposed to actually see the entire paperwork. We don't have to understand the entire paperwork, but we do need to account for all pages that should be included for that notarization. Case in point, if you see a document that says what on 3 of 3 pages, and that's all you have presented to you, then you need to ask the client or customer, where's page 1 and 2? This document shows there should be preceding pages before it, so I will need those pages in order for me to actually notarize this document. If they don't have those pages, they don't have a notarization from you. So it's very clear. Okay. Now, if you also have a situation where the documents have blanks throughout the pages, that is another thing that you want to make sure they understand. They need to fill in those blanks so that, again, you can actually have a completed document to notarize. Because those documents, if you notarize them, they can be altered where someone can add information after the fact. When you are notarizing a document, your seal should be the very last execution on that document and nothing afterwards. So that's why it's really important for you to pay attention to those details when someone presents documents to you to be notarized. When it comes to you are asked to notarize something outside your authority, like a notary protest or a private contract, once again, you need to understand what you can and cannot notarize. And many times it's all about what the document is saying. There are certain things called a notary presentment. And again, that's a document that doesn't require us to actually notarize anything. It's pretty much just making a statement of what we saw someone do. And that's not notarizing a document. So that's something that you want to constantly make sure you're not a part of when something like that comes to you from a client or customer that feels that because you're a notary, you can actually perform in this position and we cannot. Journaling the refusal. Always document why a transaction was discontinued in your notary journal. It is your best protection, especially if something happens later. You have something to actually show in your journal why you declined this notarization or why it was not able to be, why it wasn't able to be moving forward. So again, details matter. The more details you can be about a situation in your journal, it's best to do it right then and there while it's happening, because tomorrow, next week, our minds are not as sharp based on exactly what happened in those moments of the details. Okay. So when it comes to remembering what we covered, you want to stay objective. Do not let personal interests or emotions influence your duties. Stay informed. Regularly review the North Carolina Notary Public Manual for updates on laws. This is something that's really important for you to be on the mailing list for the Secretary of State. So as legislation changes, they do send email updates, so we'll know exactly what's happening. Always stay safe. Your seal is a shield for the public, not a stamp for convenience. That is really, really important to remember. So we will now open the floor for any questions that you all may have. The Q&A, I see that it's lit, so someone has already started with their questions. References you want to keep in mind. You can always go to the North Carolina Secretary of State Notary Division section, and we have a lot of resources there for us to actually benefit from on our day-to-day activities as a notary. And when it comes to what you want to always keep in mind, we are here to guard the public, and you guard your commission at the same time when doing so. All right. So let's see, what questions do we have for this topic tonight? Okay, so case number one, Miss Vicky asked, could an executor have signed the title? When it comes to them writing, or better yet, stating that they're an executor, because the difference is the position that a person holds. So if they're not signing before someone to be that person, they have to identify who they are in that act of signing the document. And that's something DMV will also get more information from them. So they have to have the paperwork provided proving they are the executor. Otherwise, we as the Notary Public, and they're giving us information about who they are and why they're needing to be the signer, then we're going by what they're telling us in that capacity. And they can't just sign the principal signer's name only. They have to lead with or continue with who they are as the document has been signed by, the name of who is titled on the actual title, as well as themselves based on their position of being able to say they can do this. So again, we are not ones to ask for proof when it comes to paperwork, but DMV will. So again, our goal is to make sure that we go through all of those questions of making sure they understand, or I should say, instructions of how they need to sign the document if they themselves are not the actual signer in the various capacities, whether it's a POA situation or an executor position. Okay, Lynn's question is, what exactly is a notarial protest or of a private contract? Um, so that is something that is a document. Again, someone is trying to state something that they're trying to prove to the court of law, and they want a notary to be a part of this process. And it doesn't require the documents to be notarized. So that's one of the things where, again, we're going to steer clear when someone's asking us for us to be a part of a situation, for us to actually verbalize what a person has done when it comes to, again, protesting what they or what we've seen. That's not us notarizing something. So some people confuse us having something notarized versus what we're seeing them do, and that is not a position that we can hold as a notary, if that helps. And Vicky says, I have asked to notarize a document or statement that a person personally wrote. I did not read the document. So when it comes to someone writing a document out that they won't notarize, we can definitely do that as far as notarizing the document, because again, the goal is to make sure that they choose what type of notarial certificate, whether it's going to be an acknowledgement, a affirmation, or oath that they want to actually have attached to that written document. So again, when it comes to spaces, if there's enough space on that written document for us to actually add the notarial certificate, I encourage that to be done that way. So you can have that one sheet. You have more of a um, you have more of a, what's the word I want to use? You have a likelihood of someone doing something fraudulent if you're attaching a document as far as a loose certificate to anything to actually notarize it. Because if they are actually criminal, they may want to actually detach the notarized certificate and put it on another document that you never saw. So that's why it's important that if we do use a loose certificate, we're going to actually write down exactly what it's been attached to based on the paper that we can identify is going to be attached to it. Because again, that is a document that's going to be out of our reach after we complete the notarization. So in your journal, you want to write as much information as you possibly can based on exactly, again, what the title of the document was, or describe the document. And then, of course, if it was an acknowledgement or a jurat, to also say how many pages it was, maybe how many paragraphs you can recall. The more details you can actually record, the better it will be when it comes to later, if you have to share what your story of what all occurred. Okay. Is there any other questions or comments? Again, this is an opportunity that if you don't have questions specifically for the topic of discussion for tonight, you can still ask any notary questions here to get a live response.
There's still one more question. I think it's Vicky. I know if someone signs DMV as POA, the seller needs to take a copy of the POA to DMV. Do they need to take the executor papers also?
Yes. Whenever when it comes to what we look for as a notary, we're just properly identifying the person that said they're signing on behalf of the person based on their title or position. Anything that's going to go to DMV and usually any other organization, like even a bank, they have to show proof of who they are in that capacity with legal documentation. Any other questions? Oh, we are really quiet tonight.
That's what I'm just thinking. Lynn has another question. Do you want to read it or you want me to read it for you?
You can read it.
Okay. When there is a POA for a card title, can you explain what exactly needs to be seen and how would the person sign? Can you cover exactly what would be done?
Okay, so when it comes to a person saying they're a POA, there's DMV power of attorney that is probably it's best for them to have those forms
Mhm.
from DMV directly. And if they don't, unfortunately, this is what DMV is going to expect. Because when it comes to a seller, the seller actually may have a POA, all right? And if they sign that the the vehicle belongs to John Doe, but you have Jane Doe, the POA for John. So she would have to sign the name for John Doe by Jane Doe, power of attorney or attorney in fact. All right. When it comes to that document, after the buyer is now actually taken to DMV for it to actually be transferred, he or she has to have proof that the seller was the POA. And because chances are they don't have that documentation because it's going to be required from the seller and not the buyer, but the buyer can't move forward without DMV having that on record. So that can be a problem, which is why the seller, if they are going to have and going to be a POA, they need to have that documentation already completed because DMV will have that on file, if that makes sense. Because I don't know much of anyone who's going to actually give a document of a power of attorney to a stranger or to the buyer because so many different situations can happen in that capacity. So unless they're both going to be at DMV and DMV is going to get it from the seller so the buyer can move forward with the transfer of title, that's the only other way it can happen because DMV is going to require proof that there's a power of attorney based on who signed the actual um, title over to the buyer. So again, someone's going to have to show proof of the paperwork that a power of attorney is in place based on the person who signed on behalf of the principal. Does that answer your question?
Can you hear me, Belinda?
I can.
Okay, so I just want to make sure I'm understanding. So we will look at the DMV. You would prefer that we have the DMV power of attorney paperwork. Once we view that paperwork, they would sign that person's name, then their name, and then you said attorney in fact. Is that what you said?
So let me back up from the beginning. We notaries are not asking for any paperwork. We don't care. It's not, we are not the ones who have to receive the proof of the paperwork. Okay. We just need to make sure they sign that they are the power of attorney or attorney in fact. So when they sign the name of the actual seller, they're going to have to say for the seller's name by their name because they're the ones who say they are the POA. So they have to put that they're the power of attorney or attorney in fact on that title when it comes to who they are on the behalf of the signer that's not there.
Gotcha. Thank you.
You're welcome. And you can raise your hand if you have a question. That way you can actually verbalize your question. Sometimes it's easier to understand when you can verbalize it versus it being read. Um, Michelle, your hand's raised.
I just have a general question. So, in an office setting, for a notary, what does that typically look like? Like if you're in a bank or if you're in some kind of financial institution, what does that typical day look like for a notary?
I'm not sure how to answer that question um, because the notary still has to notarize. I mean, go ahead and give me a little bit more, I guess, clarity on.
I
what
guess
you're asking.
because I'm thinking, with the notary, of course, sometimes they have documents that need to be notarized. Like for instance, um, do they give an oath every time they notarize a document, or is it like a one oath for the day, or I mean, how is that done? Does that make sense? Or,
I think I know what you're asking. So thank you for that. So this is what notaries, and no matter where they're at, okay, we have the same law that we have to abide by. If the certificate requires an oath, we need to administer an oath or an affirmation every single time. We need to ask the signer what do they prefer, if they prefer doing an oath or an affirmation. When they make that choice, then we administer the oath or the affirmation, and they need to say yes with their right hand raised the entire time as we're administering it to them. Unfortunately, a lot of credit union notaries, bank notaries, as well as UPS store notaries are negligent by not actually administering the oath or affirmation. I have seen it for myself when it came to me actually having documents that require a sworn statement, and they just treat it like an acknowledgement. That is a problem. So that is something that is really a big issue that needs to actually be taken care of when it comes to, I feel, at the corporate level where the notaries are and they're not doing their due diligence, because it is a problem and it can become even worse if this person has to go to court and they learn that their document is invalid because the oath was not administered. So it's that important. Did I answer your question?
you did. Thank you.
You're welcome. So I have Sequela and then Monica.
Hi. I actually, when I first started out as a notary, I worked in a bank.
Okay.
So, like Belinda said, people did come in with different documents. So it all just depends on what type of document that they that needed to be notarized. Whether if it was for an affirmation or for an oath, and I would have to step away from my platform to the other side with my stamp and do the notarization with the person, as well as have them to raise their hand if it was an oath.
Thank you for that, Sequela. We just need more notaries to make sure they know what they're supposed to do, because apparently they just don't seem to have an idea that that's even a part of the process. And it's very concerning when a notary is clueless, literally, when they're said, hey, you haven't administered the oath, and they're like, what are you talking about? No one should be able to tell or should have to tell a notary how to do their job. And that again is scary when you're dealing with situations of notaries that are not independent, oftentimes that work for a company, and they're again not aware. And it's only because they haven't taken the time to really pay attention after the class was completed to actually read, to understand what the law says we must abide by. And again, that is something that is a huge issue, statewide as well as nationwide. Monica, you're next.
I just, excuse me, I just wanted to speak on the POA with the title. So sorry I'm not on camera. So I just wanted to say that we just had that situation recently, myself and Tina, and I reached out because it was on me. I reached out to make sure that I was doing the right thing because I've done titles, but I've never had the POA. Even though I had notarized the POA and other documents for this same particular family, the person that was ill had now become incoherent, and he already had signed the title, and the son had made a video of him signing the title before this time. So with that being said, I still could not notarize that document, and I knew that he had the POA. I had to refer him to the DMV because the father already has signed the document. So I just wanted to make sure that because you had to say it again, everybody understood. Do not allow that to take place with them. And if they're unsure, one, reach out, because I know a lot of us do titles, but when it comes down to the POA and the in fact part of the POA attorney part, make sure you reach out and ask if you're unsure, because like she was saying, you don't want to get yourself in any trouble. And if you're still unsure and you have nobody to reach out to, just refer them to the DMV. You'll get another chance to do the same thing again with a different person. This time you will know for sure what you're doing and how to do it. Like I said, even though I've done plenty of titles, it's just that the father was on the video and now he had become incoherent and he already has signed the title. So those three things was a big factor.
Thank you for sharing that, Monica. And a lot of people feel that because they have something recorded, that that's good enough. But again, based on North Carolina notary law, we have to see it happening in real time, being able to touch the person. And as Monica was able to discover, things has changed with the mental capacity of the signer from her last time that she may have assisted them for another document. So that's again unfortunate when situations like that do occur. But once again, DMV, that's their document. They can actually help with provisions like that for customers. It may take them to do a lot more work. But again, we as notaries, we have a limit to what we can actually really assist somebody with. And we don't need to take on that burden or that responsibility that we have no business touching. Okay. So again, we like to try to help, but we don't want to actually put ourselves in a position of trying to help and it be a problem because it's something that is going to hurt us as well as them in the interim. So again, it's best to say no and let them know to actually take the document to the agency of where it needs to actually be addressed so they can give them the right information of how to assist going forward. I have Lynn and then Linda.
I want to make a statement and I have a question. When we come to these training, we learn a lot from you, Belinda. And a lot of times when people come to get documents notarized, because we are learning from you, we tell them what can and cannot be done. And a lot of times other notaries would allow stuff that you should not allow. And so a lot of times you have a lot of problem with some of the people that come to you because they'll say, well, the last person didn't do that, or they didn't tell me that. And so it does make it difficult sometimes when they are used to going to other notaries and they are not doing exactly what they're supposed to be doing. That's the statement I wanted to make. But the question I had was, I do have an office and I'm not always at my office. So if I'm at my office and somebody walk in and wants something notarized, I do not charge them for travel because I'm already there. But if I'm not there and they call me and want me to go over to my office to notarize something, I do charge for travel for that. I wanted to make sure, is that legal? Can I do that?
Yes, it is. It's very legal because
Okay.
you're still traveling. So it's
Okay.
almost it's nothing different than having an office that you're not currently present at to meet someone. The same as if though you're going to go to Starbucks, the library, or to their home. If you're going to and from traveling, you have the right to actually charge the travel fee.
Thank you.
You're welcome. Linda, your hand's raised.
I don't have a question. I just have a comment for Miss Monica. I would like to congratulate her for doing that because I know people feel like they feel pressure whenever they get people in front of them and all this other stuff. And I'd like to congratulate her on that. I have done titles a long time as well. But anytime they have a POA or anything like that, I always send them to the DMV. I don't mess with those like that. Whenever there's a person deceased and have a POA, I always send them to the DMV to make everything streamlined and smooth.
Thank you for that, Linda. So again, if you didn't take anything else from that, if you are not sure, send them to the agency that the document belongs to, where they can actually get more assistance. Because again, we're not an attorney either, so we got to make sure we're not giving them advice that can be a problem Okay, so we want to make sure that again we are putting ourselves in a position that we're not breaking the law, we're not complicating things more than it need to be, and we're just making sure that we can guide them to actually talk to who can possibly help them move forward. All right. Joanna, I see your hand.
Good evening. I have a
Good
question
evening.
about how can we verify the authenticity of a document if it's written in another language?
So that's an easy question to answer.
Okay.
It's not our job to actually validate an authenticity of a document that's in a different language. What we're looking for is the notarial certificate. Is it in English? If it's in English, then we can move forward with the notarization after we properly identify the signer that is signing that document. Does that help answer your question?
I guess I was thinking on the fact of what if it's something that, say, if it was in English and we look at it and you say, this document doesn't look right, that is possible fraud. It can be the same scenario, just written in a different language.
So again, when it comes to what the legislation says, we are usually reviewing a document.
Mhm.
If it's something that you feel that may be in question, okay, you can document that in your journal. But if everything looks like, everything's in place, when it comes to, you can identify the name is listed on the document. And of course, the notarial certificate, again, is in English. And there's no obvious blanks that need to be completed because, again, in foreign documents, you can see if there's something that's missing that probably need to have something there. So that is something we can always inform the customer is that we are not going to notarize a document when there's obvious places that needs to be filled in before we actually notarize the document. We can't advise them on what they need to actually put there, but we can let them know we can't move forward with the notarization if they leave it blank. And so again, they can make a decision if they're going to come back to you later with it fully executed, or you're just going to have to decline it and keep it moving. So we do the best we can. Fraud is going to happen very easily sometimes before us, and then sometimes it's going to be easy for us to identify it and say no. But again, that is something that we can do the best we can as far as properly identifying the person and writing down very detailed notes in our journal if there's a situation that may come up later that was a fraud case pertaining to that notarization, and you can just share what you identified during that time frame. And again, as long as you got detailed notes, you have something to refer to help you with that information. Well, things are going to happen that's fraud, and we are not an investigator. We're not anyone other than a notary. Sometimes you may have an investigator that's both, but again, you just go with your intuition. If you don't feel good about moving forward with it, you are not obligated ever to notarize a document, so you can turn them down.
Okay. And I had one more question. What's the difference in the notary manual and the primer?
The primer is nothing that the North Carolina Secretary of State has written. The primer is coming from a different private organization that's trying to sell more things for their company. But the manual has everything we need.
Okay. Thank you.
You're welcome. Yes, Lynn.
Melinda, it's a menu that you can actually purchase with all the IDs for all 50 states. Do you recommend that?
I do. And the only way you can get it is if you prove that you are a notary. The company that it comes from, they make sure that it only goes out to law officials as well as notaries, but they have to actually show their active status, or they have to prove their active status as a notary to gain access to that.
Thank you.
You're welcome. All right, we're doing good on time, guys. So any other comments or questions? Miss Vicky.
You're saying that sometimes a notarization might be considered invalid if an oath wasn't given. Well, if someone's asking 2 years later, did you take an oath? Most people aren't going to know. And if there's not a journal around that was marked correctly or incorrectly or marked after the fact, there's no way anyone's going to know an oath wasn't given. So how can that actually hold up? That an oath wasn't
I
given?
can't answer
How can
that
they prove it?
question. Right now, I mean, if a situation was like that to happen, then that would be up to the court to make a decision. This is why it's important for notaries to maintain journals, so they can actually have something to support what occurred. That's why it's best practice. Otherwise, now it's going to be a debate between your word against somebody else's, and that's what happens in the court of law. Either the judge is going to make a decision, or if it goes to trial, a jury is going to make a decision. It's unfortunate they're not there to actually witness anything that occurred during the time it happened. They just have to go by testimony and reach a decision in that way. So that's usually what the outcome would be, is someone having to make a decision when they were not even there based on the testimony. So is there anyone who has taken any notary trainings within the last 30 days or taken trainings in addition to our meetings in the next 30 days? Miss Linda.
Yes, I have taken this past weekend the fingerprinting role and the Apostille training.
So how was that for you?
Oh, it was great. It brought back some memories when I used to do fingerprinting, but it was very informative, and you was a great instructor. Just add on to my goals of eventually teaching others and stuff as well, because I am an instructor. So just pass on the knowledge to other people when they have questions and stuff like that. So it was very informative, hands on, very messy at times, but
When you
it
deal
was
with
very
ink.
fun. It was fun. It was fun. I learned a lot.
Well, good. Thank you for sharing.
Yeah, I think everybody should
Um,
take it to enhance their notary skills or advance out into they want to do other things with notary.
Yeah, so if you are a notary that want to actually have additional streams of income, there are various ways of you doing that. Again, I want you to make sure your anchor of why you're a notary is to really help the public, because the public is who need our services. So if you're setting yourself up to do what it takes to become a good notary, so you can actually make sure that you're notarizing documents the correct way the first time, every time. Errors will be made, but once you learn from those mistakes, it can and should help you improve for notarizations to come. As you're moving into the position of saying that you may be approaching retirement, or you don't want to take a second or third job, this could be an outlet for you to incorporate different service offerings that helps when it comes to you being a commissioned notary, that open doors for you that without the commission normally wouldn't as easy. So again, it's all about taking advantage of learning different things to find out what you may be really interested in. And it's just like sports, going through school, trying out different teams or sports itself just to feel what you really enjoy and may like more, so you can actually know what you might niche down to later. But again, I believe in exposing yourself to different things that can be beneficial long term. Ms. Vicky.
I have been joining, rightly or wrongly, several other notary Facebook groups, which gives you some rather uh, educational, shall we say, posts when people ask some ridiculous questions. But one of them was very interesting this past week. Someone was asking, "Have you ever been taken to court because of someone was questioning?" And one lady said that, yeah, the family was contesting a will. Said this the guy who signed it didn't know what he was talking about. And I'm going to read what she said. The lady says, "I always make notes. I will note pets, how I was originally contacted, anything we might have talked about that was not appointment related, if there was crazy weather or something similar that would be noteworthy. It can remind me because we cannot remember every detail of every appointment later. And she said she had reported things like we discussed the cats, we discussed, she kept reading, it says added insurance protection as a reminder, but also to prove credibility. How else could I know about an antique clock or a brand new puppy or that someone enjoys gardening? It's hard to disprove someone's account of a middle person's mental acuity if I can relay detailed discussions we had. Now, I make notes in my journal, but I don't make notes about the casual conversations. But I'm thinking if you're doing anything that could be estate related, and you want to make sure that they are of sound mind and body, as they say, comments about gardening and pets and grandchildren may actually come in handy. And I never would have thought to put that kind of stuff in a journal. I
And
usually
that
record it
again,
done on the front porch or on the hood of a car or something stupid like that. But I never thought about putting in conversations.
and that
Just
when it comes
FYI,
to questioning someone's competence, that is definitely a great opportunity when you're talking about estate planning or any type of estate planning documents where someone's mind may be called into question. You want to treat everything the same way, which is goes back to the point of not being um, biased when it comes to how we handle our ministerial duties. If we actually treat everything the same by having those extra details of what someone may have said, something you may have seen them do, or how they were acting, all of those things actually may be very beneficial if ever you are called into court having to verify or give your testimony of what all occurred. And so, to that notary, I applaud her. She may have had other situations that have occurred before. She may be a journalist or someone that does a lot of journaling. So it does have a lot to do with what you currently do already, where it can actually complement you as a notary. So if you're someone who don't mind writing, doing details, you may be an author. You write, okay, and there's usually details in the writing. So if you're someone that doesn't do a lot of writing, you might just do a lot of just more talking to text, things of that nature. You can also use an electronic journal, so that you can still use dictation when you're wanting to actually record what occurred during a notarization. So you want to find ways that you can actually make sure that you are capturing as much information as possible. And again, it may not be as detailed as the post that we just actually heard about, but the more you can put down to help your memory, the better it can be if you ever are questioned to give testimony. Thank you for sharing that, Miss Vicky. All right, so if there's no more questions or comments, we will be winding down to actually end for tonight. If you are someone that's actually, again, looking at the YouTube replay, please do like the video, subscribe to our channel, and share, so others will actually know that there's a North Carolina notary covering information that can help them on their journey as a notary public here. There's still a lot of notaries statewide that are not aware that they do have resources beyond just the instructor that they may have taken the class with, that can be very limited depending on how many classes they're teaching and their availability. They are also not fully aware that the Secretary of State has resources for us all to gain access to, which again is very beneficial if you utilize it. So help having them know that we have our weekly Tuesday Notary Tune-ups. Again, inviting them to come is very helpful. So if you have if you know a notary that is not a part of the Confident Notaries or North Carolina Facebook group, please do invite them. That is something that you have the ability to do, that you have permission to do, to help another notary know that they have an anchor of a support system here in the state of North Carolina for themselves. So thank you guys for joining. And always My motto is always be learning, always sharpen the saw. And so practice makes excellence once you actually, again, continue to apply the information you're reading by actually, again, going to your manual, studying, studying, studying. This always makes it an improvement over time. And you'll be amazed how much your mind actually remembers when you're actually having conversations with others. For those that have not joined the NC Notary or the North Carolina Notary Association, you can do so by going to ncnotary.org. And again, become a member. It's only $35 per year. We have an annual conference. We have trainings throughout the year that you have access to from prominent people who can actually help you understand a lot of things in the notary world. Um, every speaker brings fresh information to us that can be, again, something that you learn new every day. So test your knowledge to see how much you really do understand and know. We will be continuing tomorrow with session 5 with the Wednesday Notary Wisdom learning sessions covering our 2026 Notary Manual. Everyone should have theirs now. The 1st of June was the date that everyone should have the newer manual. So please do make sure you take the time to find it. You can go to the Secretary of State website and find where it says notary to become a notary, and it would point you to where you can order the correct book. If you're getting it from Amazon, you have the wrong book. Amazon does not have this book for a reason. So you want to go to the School of Government website that you can actually click through the Secretary of State to get the right manual. All right. So again, do yourself a favor, go ahead and invest in that 40 some dollars because that is what you must have when it comes to operating as a notary on any level of notarizing a document. You should have your book with you. Okay. So if you have any questions after we end, please do email me, text, or chime in through Messenger or on the Facebook group. And I'll be more than happy to actually respond, or the group that we have superior notaries will be able to answer a lot of questions as well. So I thank you guys for, again, your support, your attendance, and just again, your presence. So thank you so much for our community. And I look forward to seeing you guys, if not tomorrow night, next Tuesday.
Good night.
Good night.
Good night.